And I'm mentioning one urgent matter for appearing in the tomorrow's list, my lord.
What is the urgency?
Urgency is this, my lord. The petitioner is an employee of the Essential Commodity Corporation undertaken of the government of West Bengal. He initially applied for a different post for betterment of his career, service career, and prayed for no objection certificate. And during the pendency of that, that expired. That my candidatureship has been expired since I could not be able to produce the NOC certificate. Thereafter, I have applied for another post under the ICMR, Indian Council of Medical Research, and 9th is the date I have been shortlisted. And 9th is the date for submitting all documents for verification along with NOC and verification.
So NOC you had?
No, I am praying for NOC. They are not issuing NOC. Earlier occasion also they did not. And during this pendency, accordingly, I filed this application, which is pending before this honorable court. And thereafter, another application I have made, my lord. In this occasion, they are not issuing, and they have virtually intimated verbally that we shall not issue any NOC certificate. So 9th is the date to produce. I have been shortlisted.
What is the reason for not issuing NOC certificate?
Nothing has been written stated. I have made my representation and I have been annexing my document. I have also annexed one application. An application, I have filed also an application. Let the both the matters come to the tomorrow. I shall
The writ
satisfy.
petition of which year?
Writ petition of put to 2025.
In connection therewith, you filed an application.
Application to the present, the development of the present situation. That I have applied another post because pendency of the application, that my time has over. So I have no other scope to proceed.
Time for what is over?
Time in earlier occasion, I have filed for two prayers. One, not withholding the salary, and to grant no objection certificate, since I have been shortlisted for a particular post of a government of India. And since they have not issued, there was a particular time. Within that time, I have to submit the NOC. I could not be able to submit the NOC because neither the matter was heard nor they issued the NOC, my lord.
Which authority is not issuing NOC?
This is corporation. West Bengal Essential Commodity Supply Corporation.
Who appears for that corporation?
Yes, I have given notice. Gaurav Das, I have given notice. Oh, Gaurav is here.
Why you are not issuing NOC?
My lord, that application has on day before yesterday was served upon me.
Tomorrow, under the heading urgent motion.
May I permitted to mention extreme urgent matter? I mentioned the matter as a contempt application before your lordship. Your lordship is pleased to allow my application and directed matter be listed in the monthly list of January. My lord, I have ascertained from your lordship court officer the file has not came. That's why, my lord, it has not been listed. The person is not getting the pensionary benefit despite of your lordship. My lord, general practice of your lordship to leave.
If record is not there, what can we
My
do?
lord, I undertake bring that record.
First,
Kindly
let the record be sent in, sent to this court. My officer is also trying.
my lord, I have ascertained, my lord, since the lady is not
Yes,
getting.
please call the list.
Your lordship mentioned lordship.
Today is not a mentioning date, unless only it is extremely urgent. Yesterday I allowed mentioning for 1 hour.
There's some urgency. Yesterday.
Please don't mention any matter further.
Item number 1.
I appear for the respondents.
I appear for the state lordship.
So appear for state.
I appear for the state
corporation.
lordship.
Kolkata Municipal Corporation.
Who is appearing for the petitioner?
Petitioner advocate is not present.
That issuance of certificate.
Certificate. Well, I prepared the report.
Just a minute. That is hard. Yes, report.
The report has been prepared, but original one which by learned junior, it was affirmed on 7th of November. It was handed over to the learned advocate for the petitioner. It was affirmed on 7th November.
It was served upon the learned advocate.
Yes, ma'am.
So where is the original?
Original is with my junior, but I do not find one in the morning.
Yes, today is not the date for fixed for this matter,
Fine.
because it was fixed in the month of November by mistake of
Fine.
my officer. It was not accommodated in the list.
It was not
Very well, let this matter appear on next Tuesday. Do one thing, you are representing the petitioner, state respondents.
State.
Serve a notice upon the learned advocate representing the petitioner.
That the
On
matter
the
will
next
be-
date, you file a report.
Fine.
Issue.
Well, let it be done instead of Tuesday, well, Wednesday.
Why?
The Tuesday have some matter in the morning. That is it.
Issue. Matter is taken up for consideration when Mr. Alok Kumar Ghosh, learned counsel representing
Already আছে।
Kolkata Municipal Corporation, has prayed for accommodation to file report in terms of the order dated
হ্যাঁ।
16 September 2025.
Email করে
Next
আরেকটা
matter.
WhatsApp
However,
করে।
petitioner is not represented today. Stop. Learned advocate representing the state respondents are represented by learned advocates. Stop. Learned advocate for the state respondent is directed to serve notice upon the learned advocate representing the petitioner, including representing the petitioner by 9th January 2025, 2026. Stop. Next paragraph. List the matter under the same. List the matter under the heading assigned motion on 14th January 2026. Serve a notice upon him because my officer missed the date.
Grateful.
And
Lordship.
Mr. Ghosh file report on the.
Yes, yes, of course, madam, because it was already affirmed.
Grateful.
Item number 2.
May I please answer the petitioner? My lord, here, my lord, my candidature has been rejected on the shortfall of height. I preferred appeal through email. Subsequently, thereafter, my lord, that has not been yet considered. Your lordship's pass an order, similar order on several matters. My lord, page 21 is the rejection order. It has been
On the ground of height.
height. My lord, here my measurement has been measured at 168.4. I preferred appeal through email on page 22 and 23 and 24. But till date, they have not considered my appeal, man. Well, your lordship may-
Appeal has not been considered.
Appeal is supposed to be filed before the presiding officer.
Yes.
They have filed the appeal before the Director General possibly.
Very well, then you consider it. Who will consider it? Beside Director General?
Number 7. The IG, my lord, your lordship directed, the matter will be considered by the IG, my lord, West Bengal.
In other matters.
That's why I said that respondent number 7.
IG is respondent number 7.
Yes, my lord, respondent number 7.
Yes, Mr. Dasgupta.
Yes, through the medical.
Where is your appeal?
Appeal is page 22 and 23 and 24.
22?
23 and 24. Through email, I have sent it.
Any appeal against my judgment relating to height?
This will let-
Till date, not it.
Several
so far
appeals
as
have
my
been
knowledge
filed.
is-
In these matters, I do not know
Other
if any
matter-
appeal is been filed.
Other some matter, rounding
Because this
of
is
matter, they have. not
rounding
filed.
of matters.
Your lordship's order, no.
The judgment, against the judgment, till date, no appeal. Issue.
Well, a copy I have. Some other matter, your lordship's.
অর্ডারে কি বলেছে?
ওই সাথে consider করতে বলেছে। Appeal within a period.
না বসো তো,
Through the
কটা কপি
medical
দিচ্ছে এটা করে দিচ্ছি।
মেডিকেল সব কিছু বলার
Here the single petitioner, my lord, only one petition.
হয়েছিল না, কে ডিসাইড করবে?
Sanjay Kumar Chandra, respondent number 7. Somebody she has
আই
West Bengal sector.
সেটাই বলছি, একটা সেক্টর কিছু আছে, ইস্টার্ন ইস্টার্ন সেক্টর নাকি?
এখানে আছে সেন্ট্রাল সেক্টর আর ওয়েস্ট বেঙ্গল সেক্টর।
Yes, it's same order, respondent number 7 to decide by 4 weeks and it is to be communicated by 7 days thereafter. এটা দেখে নিন। Disposed of.
Item number 3.
Tribunal, I have got the petition.
For the union, my lord, as
Just a minute. Yes,
my lord, as per your lordship's direction, my lord, he has been declared fit in the medical, and his report has been sent to the Delhi.
so
Delhi.
your grievance stands redressed.
He has been declared medically fit. Now next course on his appointment.
To DIG recruitment, it has been sent, my lord. Now,
I am recording your submission and disposing it of.
my lord.
Yes. Matter is taken up for consideration in terms of the order dated 22nd December 2025 in presence of the learned advocates representing the petitioner and Union of India. And next paragraph, learned advocate representing Union of India submits on instruction that in subsequent review medical examination, petitioner is declared or petitioner has been declared fit, and candidature of the petitioner is forwarded to the to the concerned respondent authority, to the concerned authority for appointment.
My lord.
Stop. Next paragraph. In view of such submission, next paragraph. In view of such submission made on behalf of Union of India, it appears that grievance of the petitioner stands redressed. Stop. Writ petition stands disposed of, urgent, etc.
Now next course is the appointment.
Yes.
Kindly, as soon as the approval would come, he should be allowed to join.
আচ্ছা কি বললাম ওটা দেখো তো, ওটা চেঞ্জ করে
দেখে নিন।
না ওটা কেটে দাও। Stop. Since petitioner has been declared medically fit, concerned respondent authorities are directed to take consequential steps for appointment of the petitioner. For appointment of the petitioner in the post of Constable GD under Central Armed Police Forces within a reasonable time. Stop. Writ petition stands disposed of.
The boy is saved. I'm extremely
Grateful, lordship. Deeply obliged.
No.
I'm being led by Miss Tribunal.
No, where is she? She never appears.
But she's not been able to attend.
No, then why you are giving her name?
My lord, I apologize.
If she is not in court, don't give her name.
My lord. Okay.
That is improper steps on your part.
My lord, I tender my apology.
Yes.
Item number 4, my lord, I have for the respondent, my lord.
petitioner, my lord.
The inspector in charge, Manekchok Police Station, has submitted a report that they both are same person. Mohammad Imam Haq, son of Muhammad Tajimul Haq, and Imam Hussain, son of Dugia, same and identical person.
There is no any.
You prefer an appeal against this order. It's an appealable order. Why court will enter into this issue at this stage?
Previously, my lord, the inspector in Manichak, my lord, also, my lord, issued a certificate that there is.
I directed the police authority. Police authority has submitted a report at the same person. So it is not the appropriate time to enter into this issue at this stage.
The same, my lord, IO, my lord, issued certificate in favor of the petition that there is no.
It's a termination order is an appealable order. Yes,
My lord,
it's
absolutely.
an appealable order. Now, if today I hold that they are same and identical person, nothing will remain open.
My lord,
And it's a writ jurisdiction. I will not enter into
My
the
lord.
factual issue.
Exactly.
my lord, the state respondent, my lord, filed this report, my lord, annexing the documents of the petitioner, my lord, but there is. no-
That I will not enter into this at this stage. A termination on being found that petitioner is involved in a criminal case. Now the case is being made out in the writ petition that the person against whom criminal proceeding is initiated is not the same and identical person as the petitioner is. But the officer in charge, in terms of the order of this court, officer in charge of Manekchok Police Station is saying both are same persons.
My lord,
Now don't invite this court to make further observations on this. Then your right to, or your right to prefer appeal will be impacted.
Your lordship, but, my lord,
my lord, in addition to this, my lord, the
Yes.
shall file the exception of against this report, my lord. Your lordship, my lord. Exception.
No exception further. Sorry. Esho. Where is the termination order? Where is the termination order? Once High Court holds that both are same and identical person, nothing will remain in appeal. Page 42. Page 42 is the judicial order in connection with criminal proceeding.
Page 49, 50, my lord.
Yes, page 49. Issue. In the writ petition, challenge is thrown to the dismissal order dated 17th October 2025 passed by Commandant of 185 Battalion of Border Security Force. Stop. A case is made out in the writ petition that against one Imam Hussain, son of Duggi, Duggi. A criminal proceeding was initiated being Manikchok PS case number 443/2016 dated 19th October 2016. But petitioner is Muhammad Imam, EMAM, ota IMAM, hai? But petitioner's name is Muhammad Imam, EMAM, Haq, son of Muhammad Tajimul Haq, against whom no criminal proceeding is pending. In consideration of the case made out in the writ petition, court previously passed certain orders directing the police authorities to take certain steps. Next paragraph. However, today during course of hearing, it is pointed out by the learned advocate representing Union of India that order of dismissal dated 17th October 2025 is an appellable order. Stop. Next paragraph. In view of availability of alternative speedy efficacious remedy, this court does not find it apt to enter into the issue whether against the petitioner criminal case is pending or not at this stage. Next paragraph. Hence, writ petition stands disposed of.
My lord, since no affidavit was exchanged, my lord, kindly note that.
Writ petition stands disposed of, granting leave to the petitioner to prefer appeal against the order of dismissal dated 17th October 2025 by fortnight from date. Stop. If appeal is preferred against the order of dismissal, appellate authority is directed to decide the same in accordance with law by 3 months thereafter. Next paragraph. Since no affidavit is called for, statements, allegations made in the writ petitions are deemed not to have been admitted.
My lord, one more submission, my lord. On the last occasion, the state officials submitted a report, my lord. We need a copy of it so that we can take it from the registry. my
No,
lord.
no.
It will help us, my lord.
No, that is only for the conscience of the court has called
My
for.
lord, my lord, one more submission.
Certainly
my lord.
no, not.
No, and some other matter. My lord, one more submission, my lord. Just now, your lordship had a query whether appeal has been filed against those height matters, my lord.
Statements to allegations are statements. Statements made in the writ petitions are deemed not to have been admitted. Yes.
My lord, yesterday 4 matters appeared, my lord, and I was there appearing before.
Please don't mention any matter.
No, I'm not apprising your lordship that it appears did happen, my lord, and it is appearing before the court, my lord.
Yes.
Your lordship had a query just now that whether appeal has been preferred against that 2D. My lord, yesterday his lordship was pleased to hear the matter, my lord. Appeal has been filed. Many appeals has been filed, and out of that 4 appeals have already been heard, and the next date has been given after 23rd.
Any stay order?
No stay order as far as till today, my lord. But it will be heard on after 23rd, my lord.
Yes, next.
Item number 5.
For the respondees.
Affidavit, my lord. My lord, the present petitioner before your lordship is the second in command of the CRPF, my lord, who was discharged his duty, my lord, with the major diligence, my lord, and my lord.
Yes.
She is discharging his duty in various occasions, my lord, when she was given this assignment for this job. Several times, my lord, he has performed his duty, my lord, without any doubt or my lord. And to that effect, my lord, the several certificate has been issued by the competent authority, my lord. Kindly come to page 14. Page 14 is the, my lord, the certificate by the Ministry Central Reserve Force that thereafter, my lord, the
What you are praying for?
what I'm paying
To
for.
withdraw the advisory letter issued against your
Yes.
petitioner. Yes.
Yes, that advisory letter, my lord, says regarding.
You are working as?
My lord, the second in command in CRPF. I'm a lady officer, my lord, working in a CRPF. My lord, I was posted in Libya for the peace, my lord, what they have said, the peace team.
Peacekeeping force. Part of peacekeeping.
I was posted in Jammu and Kashmir. I was posted in Jharkhand also.
Now, advisory letter, how you are affected by the advisory
My lord,
letter?
kindly see the advisory. This is my supplementary affidavit, my lord. Supplementary down. This advisory says that my
Where is the advisory letter?
my lord, this page 4 of my supplementary affidavit starting from my lord. But here.
But no punishment has been issued, no proceeding has been initiated.
So far this
It's a warning letter.
so far that for this letter, my lord, my appraisal has been not been given. But what I am trying to impress your lordship, subject to lordship kind sanction, the point 3 and point 4 says about my misconduct. And my lord, kindly see page 14 and 15 of my writ petition. Here, my lord, the authority has certified that my lord, I have done this work with the diligence of my lord, the process.
No, how it's an warning. Suppose a show cause letter is issued
My lord,
against which a writ petition is maintainable unless and
my
until,
lord, so far,
unless and until steps are being taken, which is adverse to the interest of the incumbent.
my lord, so far, so subject to lordship kind sanction, my lord. So far, this advisory is standing on the way of my appraisal. My lord,
Appraisal for what?
appraisal for my next promotion or next posting, my lord. This advisory, my lord, if it is stand on the point, my lord.
Yes,
then
whether it will impede petitioner's right to petitioner's promotion to the higher post.
Most possibly not. I am not
Possibly not, then you
because-
take instruction. If it hinders petitioner's further promotion, then petitioner has got a case.
Yes.
Issue has to be decided by this court.
But only, my lord, if your lordship
If you
can-
submit on instruction, no, this will not create any hindrance so for petitioner's further promotion, then that is one aspect of the
My lord.
matter. But if this advisory letter is to be
But, my lord, as
will
on date,
create
my-
a hindrance
Yes, my lord.
in petitioner's further promotion, then petitioner has got a case.
Yes, but, my lord, as on date, my lord, the petitioner have no any, my lord, cause of action. Because your
No.
lordship knows.
That's why he has submitted that due to this advisory letter, petitioner's further promotion will be affected.
Lord, till date, my lord, she has not.
Well, you file a report in the form of affidavit that this will not impede petitioner's further promotion.
My lord, as your lordship desire, my lord, I will file. Or your lordship may ask me, my lord, to take instruction on the issue.
Take instruction, come back.
My lord.
Issue. Supplementary, today you are filing supplementary affidavit filed on behalf of the petitioner, which was affirmed on 15 December 2025 is taken on record. Top. Advisory letter dated 22nd April 2025 issued by Inspector General of Police West Bengal Sector, CRPF is questioned. না কি বললাম? Is enclosed to the supplementary affidavit, and it is submitted by the learned advocate representing the petitioner that due to issuance of this advisory letter dated 22nd April 2025, petitioner's further promotion will be denied. Next paragraph, Mr. Partho Ghosh, learned advocate representing Union of India, has prayed for accommodation to obtain instructions as to whether such said advisory letter dated 22nd April 2025 will create any hindrance in further promotion of the petitioner or not. Stop. Next paragraph, hearing of this matter stands adjourned. Stop. List the matter under the same heading for further consideration on 20 January 2026.
Great.
In order to enable the learned advocate for the Union of India to obtain instructions.
My lord, I have also served the prior copy to.
Yes.
Item number 6.
If may I please, your lordship, I am for the petition.
I am
My
available,
last
my lord.
petition. Copy all the parties I have served and they are- see, only one. Only one that have PFP, or the presiding officer. But that's my
Presiding officer,
presiding officer of the medical. That has come, that's why they delayed.
now what you are praying for?
Yes, paying for here, my lord, I am challenging the order passed by the DME detailed medical board as well as the repeat medical. My lord, page 23 of.
Where is your affidavit of service?
Yes, my lord, I am.
I have sir, my lord, my clerk is, my lord, kindly take sir 2 more.
Tomorrow, not today. Take it back. Next.
Item number 7.
My lord, in item number 7, on the last occasion, my lord was pleased to direct the, my lord, learned advocate general to appear before your lordship.
Yes.
In this matter, my lord, as instructed by learned advocate general, I am praying for my lord only not today. Let it be fixed. Tomorrow, my lord. Yes, he will do it.
But I am appearing.
Yes.
But I am appearing on behalf of public service.
My lord,
Yes, Mr. Bhattacharya, that issue. I want to hear Advocate General.
day after tomorrow. Day after tomorrow. পরশুদিন দেখে
Tomorrow.
Tomorrow I have a jet reference fixed at 12 noon.
Oh,
Very well, Thursday.
Thursday.
Well, tentatively Thursday, will not.
Yes.
In any way, will not get entangled. Kindly accommodate. It's important issue. I will
Yes,
Yes,
yes.
yes. Therefore,
Because
my lord has cited.
court is also thinking over it. Mr. Bhattacharya, what is passing through the mind of this court is this. The junior pointed it out in view of the dicta as contained in Matthew Roger, paragraph 392 perhaps, that in absence of tribunal or when tribunal is non-functional, in that
Yes.
event writ petition is maintainable. Now, there are two aspects. There is one aspect that if tribunal is constituted, but it is not functioning. Another is tribunal is not constituted in any union territory or in state. If tribunal is not constituted, then there is one aspect of the matter. But if tribunal is constituted under 1985 Act, but due to absence of or since the vacancies are there and those are not being filled up, tribunal is not in a position to consider the original applications. Now, whether the writ court can be transformed into a tribunal.
No, Lord, I will satisfy Lordship.
And taking note of vis-a-vis the observation made by the Honorable Supreme Court in L. Chandrakumar, paragraph 90, 92, 93.
The L. Chandrakumar categorically states that the part of judicial review, which is the inherent part of constitutional code like 223-32, cannot be taken away.
Yes, it's a basic feature.
Cannot be taken away. But when an constitutional empowers the formation of tribunals, the tribunals will act as fast court, nothing beyond. Like that, when you move a writ petition before this court, no single bench, fast court, then division bench. Here, tribunal has practically substituted the fast court. And if that tribunal is not functioning, then you have to approach the fast court.
Then the high court can be transformed into a tribunal.
The high court is
when the tribunal is there.
If non-functioning means no tribunal.
Because in L. Chandrakumar, repeatedly it has been.
Ranganathan Lordship is well aware of this. When Milord, the Tamil Nadu government employees were dismissed.
Yes.
The Supreme Court found that the tribunal is not constituted because of one member available.
Yes.
Therefore, no question of pushing them back to tribunal. The High Court has rightly.
Yes, in Rangarajan's case, Mr. Firdaus Shamim also yesterday in a similar issue, all are coming before me, was arguing 2003-6 SCC 581. But there special exceptional circumstances was considered by the Supreme Court that the 2 lakhs employees were dismissed because they participated in a demonstration. But because whether it will be considered as a special circumstances for which the writ court single bench of the High Court will be transformed into a tribunal when there is a tribunal there in the state.
In case Lordship will probably has not been shown that the Supreme Court says that tribunal is also not constituted because only one member. Therefore, they cannot even go to the tribunal. Apart from that huge number, we are assuming huge number is not there. Even then, they could not approach because the tribunal was having one member. If your Lordship kindly sees the Ranganathan once. Or I will argue that.
Yes. That will be better.
It's interesting.
Interesting.
This is the first court. L. Chandrakumar says the tribunal is the first court. Repeatedly.
But at the same time, Mr. Bhattacharya, at the same time, ponder on this, that if repeatedly it has been observed in L. Chandrakumar that High Court is not substitute for tribunal. Now, if I accept your contention or the position that tribunal is non-functional due to pendency of vacancy, whether High Court, single bench of the High Court can function as a first forum.
If I may take you from my lord, the expression was the tribunal is not the substitute of High Court. Not that the High Court is not substitute.
Yes.
Tribunal is functioning as a supplemental force.
Repeatedly it has been observed. Now,
Supplement-
if tribunal is non-functional, due to pendency of vacancy in the tribunal, then division bench of the High Court can take notice of it in exercise of power of judicial review.
The division bench then is not treated as a fast court. That's why, my lord, when the Supreme Court held that the tribunal can go for judicial review as fast court, and any order from tribunal go to division bench. That means the tribunal was taken to be just, my lord, listening the burden of the first court. That's why any order passed by tribunal go to the division bench. As similarly done, if your lordship passes any order, somebody is feeling aggrieved, he has to go to division bench. In fact, the tribunal was constituted to less the burden of the judicial review court at the first.
And Mr. Bhattacharya, please, on the next date when you will advance your argument, please focus on the issue that it's a special circumstances.
Yes.
As it was considered in Rangarajan's case.
Ranganathan were two aspects. One was huge number, and another was the tribunal was not constituted. Lordship will kindly take Ranganathan down. আমি আমার তো দাগ দিলাম, আমার দাগ দেওয়াটা গেল।
Yes, in the recent judgment, Mr. Shamim yesterday pointed out this judgment. It's a reportable judgment in Lilavati N and others versus State of Karnataka and others, where Mr. Bhattacharya in paragraph 28, Rangarajan was considered by the Supreme Court. And it has been observed in paragraph 28 that it is to be noted that this court in T.K. Rangarajan, Supra, has not made any departure from the binding precedent laid down by Constitution Bench in L. Chandrakumar Supra.
Yes.
And the only observed that the High Court therein was faced with an extraordinary circumstances which called for its interference because the state government had dismissed about 2 lakhs employees for going on strike.
That is one aspect. Other aspect, I'm reading out for minus consideration, paragraph 25.
Rangarajan, just a minute.
My lord, may skip over the first few lines.
Paragraph 25.
25.
Yes.
Kindly come to for those
Yes.
Those employees who are not reinstated in service on the ground that FIR law against them or after holding any departmental inquiry penalties imposed, it would be open to them to challenge the same before the tribunal, and tribunal would pass appropriate orders, including interim orders. It is unfortunate that the authorities concerned are not making the tribunals under act functional and effective by appointing. Tribunals are not functioning. Justice should not be denied to the affected persons. In case the tribunal is not functioning, it would be open to employees to approach the High Court. And when our division bench, we similarly had passed orders, 2 division benches saying no, the first court as read court would be available.
That I have seen, but there are no dicta of the Supreme Court.
No, my lord is absolutely right, but no, the division
with
bench
greatest of respect and with all humility at my command.
But your lordship ultimately would be helpless but to comply them. Ultimately, lordship cannot go beyond that. But all these orders, starting from L. Chandrakumar, this Ranganathan, that the forum, if not available, then High Court is the forum for judicial review, probably which was troubling my lord with that single bench or division bench. That my lord will find that the Supreme Court categorically states that tribunal being the first.
That is one of the hurdle I am facing because the division bench order is there. Mr. Bhattacharya is right in pointing out because that order comes in favor of Mr. Bhattacharya's client. But the thing is this, Mr. Bhattacharya, you have seen that this order.
But anyway, we can't go beyond that. Judicial amity compels you in spite of your conscience being otherwise speaking. Your lordship may please to observe, but ultimately has to.
Whether court can, if the single bench finds that the dicta of the Supreme Court was not considered by the Supreme Division Bench, in that event court can refer the matter before.
You may give your opinion, but still then you will be bound by the judicial amity and the precedents. Or you have to then say that division, it should be placed before the division for reconsideration.
Yes, yes, yes.
That you have to see.
In one of the matters where 10 years service is necessary for obtaining pension or being eligible to get pension, so far teachers are concerned, there's a division bench order. Justice Dotto sitting singly referred the matter before the division bench.
Refer for reconsideration.
Very well, I will hear you.
আপাতত বৃহস্পতিবার মনে নেই যদি হয়ে যায়
Mr. Bhattaji, I will accommodate you because court wants to hear both of you.
Deeply honest.
No order today.
All right. Deeply honest.
এটা পাঠিয়ে দেবে আমার কাছে রঙ্গরাজন 15 দিন দিয়ে। Thursday. Mr. Shaha, tell Mr. Advocate General to appear in this matter because this is an issue where presence of Advocate General is required for the assistance of this court.
Your Lordship, I will give the L. Chandra Kumar and Roger Matthews copies to your Lordship.
No, it is there. You relied upon that book is with me. L. Chandra Kumar, your friend Mr. Shamim yesterday filed before me, and I have a soft copy. No issue.
My lord, very recently, regarding the tribunal,
Yes.
Supreme Court passed one judgment on 25th of November 2025. All the tribunals whose appointment is done under the Tribunal Reforms Act 2021, that is void. That is the very serious factor. And my lord, during the argument before the Central Administrative Tribunal, I have submitted that. And before the Andabeng bench, all the advocates of the Bar Association, they have denied to appear after the judgment because their appointment after
In the State Administrative Tribunal as well as Central
every tribunal, even my lord, the Income Tax Tribunal also. But my lord, our cat, except I am and another advocate, argued that our matter was urgent for a long time, but everybody is appearing. Anyhow, they are appearing well, but this particular judgment creates a serious
But
problem.
that is not the issue before me. So far,
Not issue, but my lord, if that will comes, then my lord, everyone will face the where they will go, my lord. And my lord, particularly in one matter by the Honorable Justice Dipankar Datto, I appeared. My lord, in that matter, the DR80 was not functioning at that time. And my lord, this honorable court was entertained the matter, writ petition, and ultimately interim protection was also given, my lord.
Since DRAT was
Not functional.
was non-functional at
Was
that
not
material
functional
point of
at that time, my lord.
Yes.
Lordship has to decide this.
Yes. Because other matters are coming regularly.
I have also matters. Now I have been engaged with him also. I'm also assisting Mr. Bhattacharya.
Thursday.
Otherwise, we'll be losing one forum.
Item number 8.
Lordship, in this matter, I am appearing for the petitioner, Lordship. The petitioner was, Lordship, declared to be medically unfit.
So you have challenged the review medical board report.
Medical report. Rejection was on the ground of a scar mark on a right hand forearm.
What is this? Big
Hypertrophic
scar.
Big hypertrophic scar.
Your Lordship will find the measurement in the earlier medical examination by the same board, which is at Lordship page
Big hypertrophic scar.
Page 18.
Well, you have to demonstrate that this should not be a ground for
rejection.
declaring a candidate unfit based on the guidelines of
2000
May 2015.
2015 guidelines, your Lordship also deal with the guidelines in a matter regarding chest. Now, Lordship, if your Lordship kindly consider the point number 14 and 13 and 14, Lordship. I have the entire guideline in my.
Yes.
I am, Lordship, just handing over the part, Lordship. If your Lordship required, I will.
Yes, which clause you are relying upon?
13 and 14 only.
13 and 14.
14, Lordship. Page 33, point number 13 and 14.
Recipient sites. So the scar is one of the reasons to declare a candidate unfit.
So, Lordship, in this two point, Lordship, 13 says that, Lordship, where there is requires, Lordship, frequent outpatient treatment. And 14, Lordship, is a grafting regarding, Lordship, burning injury, where, Lordship, some grafting is required for the treatment. In my case, Lordship, it's a, Lordship, scar marks happened due to some glass was, Lordship, broken glass was inserted in the skin. If you, Lordship, kindly consider page 18. This was the medical report, Lordship, where I was declared to be fit in their.
See, the very object of the medical report by the general practitioners or the doctors in medical hospital and the reports relating to appointment in the post of constable GD is completely different.
No, I am.
So therefore, the purpose is different also.
Purpose is different. So
You have to wear certain jackets and other things for safety and security, for taking safety and security measures. Whether this card will create any difficulty or not, I am not a medical expert. So therefore, when the scar is one of the grounds, then why court will interfere in this?
While, Lordship, scar when can be a ground for rejection? Now, Lordship, my scar is kindly consider page 18. It is a report by the authority itself.
It is hypertrophic scar.
Hypertrophic scar, Lordship, while, Lordship, during the period of, Lordship, accumulation of collagen, its, Lordship, created, Lordship. And, Lordship, the measurement, and, Lordship, kindly consider, Lordship, page 18 once. So hypertrophic scar does not come under this criteria for rejecting the candidature.
এই নেট পাওয়া যাচ্ছে না কেন? নেট নেই, আছে? পাচ্ছি না। এই যে দেখাচ্ছে এই এটা, কিন্তু আসছে না কোনখানটা। এটা কি S18GJ?
May I assist your lordship?
Just a minute. Without net assistance nowadays it's very
I have
difficult.
already.
You may have, but in other matters also I need to
Yes,
see the
required to
judgments
be
and other
considered.
things. Just a minute. Huh? দেখছি। Not for your matter only.
Lordship, I have previously I have lordship get it for myself, lordship. Hypertrophy, meaning of hypertrophic and the lordship effect of the same.
একবার না অফ করে অন করে দাও না। ঠিক বলেছো, আগের দিন তুমি বলেছিলে। এবার আসবে। হ্যাঁ 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 হ্যাঁ, মনে হচ্ছে হয়ে গেছে। Heart is very important. Scar or any other chronic skin disorder.
Skin disorder.
So, general scar
General scar in
will
nature
create hindrance.
that requires lordship.
So, how court will enter into this issue?
Kindly consider the next line.
You file a report. You file a report disclosing why petitioner was declared unfit.
And my lord, that particularly in that aspect, my lord, the various division bench judgment is also there, my lord. I am just now handling.
First, you file a report, then I will consider the
This
judgment.
is my report, my lord.
Because lordship, may I
Oh,
submit
in the
Report
form of
in the
affidavit.
form of affidavit. Issue.
may I submit one thing, lordship, one line.
Petitioner participated in the selection process for being appointed as Constable GP under CAPF, under Central Armed Police Forces, within bracket CAPFS, close bracket, stop. However, in review medical examination, petitioner was declared unfit. Stop. Review medical examination report dated 24th November 2025 is questioned in this report. Is questioned in this writ petition. Stop. As next paragraph, as per review medical examination report, the reason for declaring the petitioner unfit is big hypertrophied HYPERTROPHIED, big hypertrophied scar, page 23 te pabe. Big hypertrophied scar. Stop. Next paragraph, learned advocate representing Union of India has made submission based on observations made in review medical report dated 24th November 2025. Next paragraph. Concerned respondent authority is directed to file a report in the form of affidavit disclosing as to why petitioner was declared medically unfit. Stop. Let such report be filed by 3 weeks from date. Stop. List the matter under the same heading for further consideration on 4th February 2026.
My lord, the view of your lordship and the division bench view is exactly on the same.
Completely different, lordship, because the marking big hypertrophic, the measurement is 7x2. 7x2 in the earlier medical examination.
If it is tattoo, you are not entitled.
Yes. That
How it affects? Now the authority can make their own guidelines according to their own requirement. Sorry.
My lord, particularly for my satisfaction, I also consulted my friend doctors. My lord, in this area, that may not be the problem, but in hill area, where the temperature is very low, that will create a serious problem.
Scar creates problem.
Scar create problems because lordship, because in the
Then the candidate will pray for transfer.
Yes, that is also considered in the division bench judgment. That was also
That
considered.
I am not feeling comfortable
where there is
and my health
Yes,
is being
yes.
deteriorated.
Yes, exactly. That language is my lord considered in the division bench judgment also.
where there is any immediate
Yes, yes, file report.
lordship, it is
File report.
Item number 9.
For the respond this much.
Yes.
Page 23, if your lordships kindly come. At top.
Page 23.
Yes, madam.
Yes.
This is the examination of 2024 and the particular examination of 2025. By this time, he might have developed my lord tattoo, because your lordship will find the fit certificate issued in 2024, though he was not qualified in.
Why he was not appointed after being declared medically fit?
Lord, that is not under challenge, so I have not taken instruction on that issue, because
no, if a candidate is declared fit, why you
thereafter, my lord, there may be, my lord, some
other reasons,
my lord, for which, my lord, he has not challenged that part.
Yes.
Now your lordship will find in 2024 examination he was found fit and there was no indication of any tattoo. In 2025 examination there was an indication of tattoo and other reasons also there.
In 2024 examination, there was no indication. In 2024 selection process, in medical examination, there was no report of tattoo or tattoo removal scar.
Nothing. You'll also find from page 23. You'll also kindly see. By this time, he may have developed tattoo. And this document is for the different. You'll also will find also the roll number is different.
In 2024 report, in 2024 carrying angle is there.
What my learned friend is saying is absolutely incorrect.
Yes.
Kindly have a look on the
page 23.
Page 23, clause 1. Reason for medical unfitness. First ground is the tattoo scar mark, removal of tattoo. First ground, removal tattoo.
Significance.
Yeah, that may be.
Scarring due to tattoo removal.
Document.
Yes, Mr.
Particular ground.
But that document, my learned friend cannot rely.
Significant scarring due to tattoo removal from
forearm.
But ultimately, this document has no use at this stage. Even if I accept.
Question is, if in the previous selection process,
he has not selected.
Petitioner was declared fit,
but
having that
after removing tattoo.
My lord.
Then why on the identical ground petitioner will be declared unfit?
But
in the subsequent selection process.
But there may be the reason that subsequently there was.
It may so happen, Mr. Kundu, that he may create a further tattoo.
Can it be done, my lord? I'm asking to put.
Because I have to rely upon the judgment of the division bench.
Yes.
So far, the report of the previous selection process that will not create any right upon the
petitioner. Yes. But on the same self ground, they cannot reject. It will be the miscarriage of justice.
Who knows?
Injustice of for
who knows that in the meantime he did not create a tattoo. He did not. He did not make a tattoo.
He knows very well this thing that the tattoo is the
The
ground
court will
for
not
rejection.
enter
And
into
only
into the court will not make any conjecture or surmise
that
whether he made tattoo or not.
yes, particularly that point which my learned friend has been taken, that is not the ground for rejection. I have specifically taken this ground in my writ application. But tattoo scar removal, tattoo scar mark, and the even if my lord, the scar mark of tattoo removal is there, Commando Hospital declare fit, other selection process declare fit.
Tattoo removal scar is not a ground for declaring
Yes.
unfit. Yes, Mr.
My lord,
Ghosh,
this
there
is
is
the medical
another
guideline.
there is another
Your
aspect.
lordship's earlier occasion also.
There is another aspect. Yes, if court proceeds on the premise
My lord,
that petitioner made subsequently tattoo
my lord.
at his forearm, and that prior to his examination, medical examination, he removed it. Now, tattoo removal scar is a ground.
Yes.
Show me.
But that has been
Show me.
Your lordship, page 22, my lord, kindly see.
Show me from the guidelines.
Of the guideline, my lord, I have to check.
Yes.
Because tattoo is, my lord, the ground of rejection.
You are representing Union of India. It is supposed that you know the guideline. If court proceeds on the premise that there was tattoo, tattoo was removed. Tattoo removal scar is a ground for declaring a candidate unfit.
My lord, my learned friend, my junior is, my lord, insisting. If your lordship kindly see,
So-
my lord, B.
Yes, yes.
B. In the case of left, my lord, there was no problem. But in a case of right, there is a problem.
Show me the tattoo removal scar is a ground where it is provided. Tattoo is a ground.
Yes.
That court knows. But tattoo removing scar is a ground. Show me. I have seen this part of your
Yes.
guidelines on many occasions.
Yes.
I did not
Kindly allow me,
find.
my lord, file a short report so that I can explain.
No further report. You come on instruction whether tattoo removing scar is a ground for declaring a candidate medically unfit.
Very well, my lord.
Because if I accept your contention that yes, previously there was a tattoo removing scar, but that was not found a ground to declare a candidate unfit,
My lord.
and petitioner was declared fit, but that is not the why petitioner was subsequently not being selected for appointment. That is not the issue in this writ
My
petition.
lord.
Now, if I accept further submission that yes, petitioner made tattoo, but before medical examination, petitioner removed it by laser therapy. Now, after that, if there is a scar, tattoo removing scar, is it a ground to declare a
My lord, I
candidate
understand. I will take
unfit?
it. I understand, my lord.
Issue. Mr. Ghosh, learned advocate representing Union of India, in reference to your present review medical examination is examination report is page 22.
Page 22.
Unfit due to multiple post tattoo removal scar mark present over right forearm with unknown
removal, which may
আচ্ছা কি বলছিলাম
Unknown removal date which may hamper in
Mr. Ghosh,
combat duties, nahi?
competence.
Combatized duties.
in reference to review medical examination report dated, it is dated 1st
It is
December
date-
2025.
my lord,
1st December 2025 has submitted that due to tattoo removal scar was found present at a particular part of the body of the petitioner, petitioner was declared medically unfit. Stop. It is also submitted that previously petitioner may have been declared medically fit in connection with 2024 selection process. As per review medical examination report dated 16th October 2024, though petitioner had tattoo removal scar, but it may so happen that petitioner made but it may so happen that petitioner subsequently made tattoo which was removed prior to medical examination in connection with the present selection process. Next paragraph. Next paragraph. Question arises for consideration whether tattoo removal scar is a ground to declare a candidate medically unfit. Next paragraph. Mr. Ghosh, learned advocate representing Union of India, has prayed for accommodation to obtain instruction. Stop. Hearing of this matter stands adjourned. Next paragraph. List the matter under the same heading for further consideration on 20 January 2026. Take it back. This is your copy.
No, আমাদের copy. এটা আমাকে একটা soft copy দিয়ে দাও তাহলে আমাকে।
I did not find anything
Yes.
in the medical exam in the revised guideline.
I have also not found.
Tattoo is a ground.
Yes.
But tattoo removal scar is not a ground.
Well, I have also not found. That's why, my lord, I don't want to take responsibility. Yes, my lord.
Item number 10.
10, my lord, I am for the petitioner.
কোন জায়গাটা?
Varicose
Epidemal
nevus.
My lord, in page 22 examination, I have declared fit having that mark. It is a birthmark, and 24 examination also I have, my lord, passed. It declaring birthmark on chest. My lord, the authority concern itself declared that this is a birthmark on chest. Page 25.
Yes. What is your instruction?
My lord, এটা দেখাবো তো?
To obtain instruction.
বলুন। My lord, rule 8, my lord, if you lordships kindly see, my lord, the clause 8 of the rule.
Rule 8.
My lord. Pitching.
দেখা করবে 4:30 পরে। Clause 8 says that congenital or acquired anomalies of the skin, such as nervy or vascular tumors, is also a ground for declaring a candidate unfit.
But this is not my case. My lord,
Yes, your
that
case
the
is
new-
congenital deformity
No, my lord,
of skin.
that is the it is a birthmark, and that is
Yes.
a tumor or any other accumulation of other my lord, anomalies on the skin.
Issue.
Well, this is a fit case to refer the aims. Whether it can be ground for rejection or not, they can.
In terms of the order, matter is considered in presence of the learned advocates representing the petitioner and in honor of India. Stop. Next paragraph. A report of commandant within bracket ESTT establishment close bracket for Inspector General BSF South Bengal dated 1st January 2026 is filed today and same is taken on record. It is disclosed in the report that in review medical examination conducted on 2nd December 2025, it was found that petitioner was having epidermal nevus on within bracket A left close bracket hypochondrium region lateral hypochondrium region lateral দরকার নেই, and the candidate was sent to JNM Hospital Kolani for specialist opinion. Stop. The dermatologist of JNM Hospital Kolani opined it is a case of varicose epidermal nevus. Stop. As a result whereof review medical board declared the petitioner unfit. Stop. Next paragraph. Reliance is also placed on the relevant part of the guideline which provides congenital or acquired anomalies of the skin such as NAVI or vascular tumors are grounds for declaring a candidate unfit. Stop. Next part. This court is not an expert in medical field. And as such, court has to consider review medical examination report on the anvil of relevant guidelines. Stop. Moreover, object of medical examination of a civilian by a general medical practitioner / hospital and medical examination by medical experts for the purpose of recruitment as a member of discipline force is completely different. Stop. Next paragraph. Therefore, considering the report of review medical board dated 2nd December 2025, no relief can be granted to the petition. Stop. Writ petition stands dismissed. Next.
Item number 11.
7 Here, my lord, my candidature has been rejected on initial board, my lord, detailed medical examination board, that is page 23. Four grounds has been assigned. Thereafter, in 3 grounds, I have passed.
You are declared medically unfit.
Medically unfit.
Review medical report.
Page 26.
26.
Page 26.
Unfit due to pigmented
nevus and unable to sit in squatting position.
Both.
And unable to sit in squatting position. So where is the anomaly in this report?
Pigmented, pigmented nevus. It is a like Bruno.
And unable to sit in squatting position?
They have took me the orthopedic, the page 25, 24 and 25. In a specialist opinion, the specialist orthopedic doctor says that I can sit squatting position, and there is no orthopedically anomalies in my lower limb. They have checked me at the JNM hospital. On the basis of the report, specialist opinion, without looking into it, they have rejected. Both the doctor, they have taken up.
Well, file a report. Yes. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner participated in the selection process for being appointed as Constable GD under Central Armed Police Forces. Stop. Petitioner was declared medically unfit in review medical examination, which was conducted on 29 November 2025. Stop. The ground for declaring the petitioner unfit is pigmented nevus on right thigh and petitioner was unable to sit in squatting position.
Squatting.
Stop. Next paragraph. Learned advocate representing the petitioner. Next paragraph. Concerned respondent authority is directed to file a report disclosing as to why petitioner was declared medically unfit based on the provisions as contained in the relevant guidelines. Next paragraph. Let such report be filed by 3 weeks from date. Stop. List the matter under the same heading for further consideration on 4th February 2026.
Much obliged.
Yes, call the list.
Item number 12.
I have also
I am
been,
for the
my lord,
respondent, my lord.
rejected during the, my lord, review medical examination, page number 101.
101.
101, my lord.
It's not readable.
My lord, I have the copy of my brief, my lord, where it is quite visible, my lord.
Give me readable,
My lord,
legible
I am
copy.
providing, my lord. It is happy then too.
Tachycardia
Tachycardia, my lord.
with raised total cholesterol
Raised
level.
Cholesterol level.
Lord, tachycardia, your lordship, my lord, is an increased heart rate. My lord, it is not a permanent condition, one. And second, my lord, while doing the, my lord, cholesterol test, my lord, I was not told. So I did not, my lord, I was not fasting. My lord, I had breakfast and this report was done. And tachycardia, my lord, with regard to tachycardia, there is a revised guideline for the review medical examination that the person needs to be hospitalized and regular checkup will be done to ensure that this is not a permanent condition.
Has it been stated in the guideline
My lord, it is stated, my lord. Kindly.
that person has to be hospitalized?
My lord, kindly.
Show me.
Kindly. My lord, Annexure A to the, my lord, 2021 guideline. Clause E.
Just a minute.
My lord.
If heart rate is over 100,
Over 100.
then it is called
Then it is
tachycardia.
tachycardia.
And
My lord.
still you want to be part of
My
discipline
lord,
force.
that can happen, my lord, due to, my lord, sudden anxiety, my lord, examination related stress, my lord, your lordship will.
Your heart rate is better than your client.
My lord, kindly considers tachycardia, my lord, symptoms. It can be, my lord, it is not a permanent condition. And, my lord, why I am stressing that, my lord, after, my lord, I have gone to, my lord, independent, my lord, medical, my lord, facilities. There, my lord, kindly sees my ECG is normal. My lipid profile is normal, 102, 104. And I have, my lord, asked her to repeatedly do that. And she has done that more than twice. After this,
File a report.
my lord,
My lord,
Today I was inclined to pass an order dismissing the petition.
I'm
Get her to
grateful,
file
Lord,
a
I'm
report.
my lord, my copy of brief, man.
Petitioner participated in the affidavit of service.
my
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner participated in the selection process for being appointed as Constable GD in Central Armed Police Forces CAPFS. Stop. In review medical examination, petitioner was declared medically unfit. Petitioner was declared unfit on the ground of tachycardia and raised in total cholesterol level.
Increased cholesterol.
Increased total cholesterol level. Or high cholesterol level. High cholesterol level. Stop. Next paragraph. Concerned respondent authority is directed to file a report in the form of
My lord, one humble submission, my lord. In the form of affidavit, my lord, DIG has to come, my lord. We are facing.
Is directed to file a report disclosing as to why petitioner was declared medically unfit. As to why petitioner was declared medically unfit based on relevant guidelines. So let such report be filed by 3 weeks from date. Next paragraph. List the matter under the heading motion in the monthly combined list of February 2025.
Mashallah.
Yes, next.
Item number 13.
Well, this is my application.
I am for CSTC led by Mr. Bihar.
Petitioner was an employee of CSTC. My lord, he has got 20% of Provident fund and the rest amount 80% has unpaid, my lord. My lord.
So you receive 20%?
20%
PF.
PF.
So you are claiming 80% PF.
Yes, my lord.
Then what are the other claims?
My lord, gratuity received in belated, but interest should be
Interest on gratuity.
Yes, my lord. My lord, earlier occasion your lordship has pleased to pass an order.
Give me a copy of the order.
Yes, this is the order copy.
When you retired?
My lord, retired on 31st October 2024.
State Transport, Kolkata State Transport.
Calcutta State Transport Corporation.
So leave salary, you are not making any claim. It was paid within time.
Yes, my lord, leave salary. I am claiming interest.
Interest on 80% provident provident fund, 80%
Yes.
provident fund along with interest.
Yes.
So far 20% it was paid in time.
Yes. 20% amount has already been paid, my lord, 21st.
So you are not claiming any interest on 20% provident fund?
I am not claiming 20% which was paid.
You are not claiming any interest on 20% provident
Yes,
fund?
madam.
You are
Yes.
not claiming?
No.
Yes. You are for the state. You alone is appearing for the state.
My lord, I lead by Mr. Vikas Chakraborty.
Where is he?
He's
Are you an impaneled advocate of state? Then why you are appearing?
lead by Mr. Vikas Chakraborty.
If you are not an impaneled advocate, don't appear. Where is, if Mr. Chakraborty is there, tell him to come. Otherwise, his name will not be recorded.
No, he's high fever. That's why he's not.
He has not come. So therefore, his name will not be there. ডিসপোজড অফ। এটা কারেকশনস করে দিয়েছিল, দেখে নিও।
Grateful, Lordship. Item number 14.
Appear on the petitioner in item number 14, 15, and 35, Your Lordship.
Yes.
In item numbers 14, 15, and 35, Your Lordship. Lordship, I'm filing my affidavit of service. Respondent numbers.
Who is appearing for the respondents?
This is being taken up for the first time.
Yes.
I believe we have already served respondent number 1 and 2.
Why?
3 and 4 have not come back, Your Lordship.
Why you have served only on 1 and 2?
Your Lordship, we have attempted to serve all 4, Your Lordship. We have attempted to serve all 4. 1 and 2 have been delivered. 3 and 4 has not been.
The service is not complete. Say so. Why you are making such a lengthy submission relating to service? Take it back. This is not a service at all. You need to complete service upon all. Issue. At the time of call, learned advocate representing the petitioner prays for accommodation to complete service of notice upon all the respondents. Stop. Let notice be served upon all the respondents by fortnight from date and affidavit of service be filed on the next date. List the matter under the same heading for further consideration on 3rd February 2026. Next.
Item number 15.
Item number 15 is similar.
Same.
35.
So why two matters? Two different petitioners?
Your Lordship, they are all 3 different petitioners, Your Lordship.
Same order.
Item number 16.
My lord, Mr. Pinaki Patel is appearing for Union of India in item number 16 to 21. One matter.
Who is appearing for the petitioner? Devashish Kundu. Where is he?
One matter is going on in court number 8. Kindly make a short pass over.
You are appearing for?
I am not. Mr. Pinaki Bhattacharya is appearing for union of all the respondents in 16 to 21.
Where is Mr. Kundu? Not today.
Item number 17.
Minus same.
Not today, Coronato. Record an order. At the time of call, no one appears for the petitioner and no accommodation is paid for. Stop. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 13 January 2026. First matter gone. Next matter.
16, my lord.
Yes. 17, not 16.
What is it? 16? No, 17.
Aja dako.
16 to clear. 16 to 16.
Item number 16.
16, my lord.
Yes.
Yes, my lord. This is my affidavit for service.
16th?
16th. My lord, my candidature has been rejected on the ground of, my lord, page 26.
Page 26, renewal 27.
Post-ban hypertrophic scar.
Post-ban.
Yes, it's not permissible.
Well, that is permissible.
A few matters back, the provision has been placed before me.
Yes, that is
it's not permissible.
Well, condition is has been there mentioned. In which condition?
File a report. File a report. File a report. Issue.
Well, as page 32, in earlier selection process,
Petitioner affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner participated in the selection process for being appointed as Constable GD under Central Armed Police Force System. In review medical examination, which was conducted on 4th December 2025, petitioner was declared unfit on the ground of post-burn hypertrophic scar
Left thigh. Left thigh.
on left thigh.
That is my identification mark is page 32 I have mentioned. In earlier selection process, they have declared fit.
Stop. Next paragraph. And concerned respondent authority is directed to file a report disclosing as to why petitioner was declared medically unfit based on relevant based on revised relevant provisions of revised guidelines. So let such report be filed by 3 weeks from date. List the matter under the same heading for further consideration on 9th February 2026. Next.
Item number 17.
17, may I please, Your Lordship, with my affidavit of service. My Lord, here my candidature has been rejected, page 22. Twofold ground.
Review medical examination, page 23.
23.
22 and 23.
My Lord, DNS.
What is DN?
My lord, I can't understand, my lord, because my lord, the coffee is, my lord, illegible, my lord.
My Lord, DNS, page 22.
DN?
DNS. My Lord, that Your Lordships also hold that, my Lord. Deceptive nasal
Septum.
Measles?
Deviated nasal septum. Not deceptive.
Sorry, my Lord.
Deviated nasal septum.
Septums. My Lord, in page 24, I have checked myself and before the ENT specialist, doctor of my Lord, Medical College and Hospital. They have said that this, my Lord, I have fitted on my DNS.
In earlier occasion, my lord,
It's also directed
to
matter.
Kollani Ames, my lord,
My Lord, for deceptive nasal.
another matter,
My Lord, in my instruction, they have declared fit by that Kollani Medical, IM's Kollani. And
What is stated, page 24, petitioner is, patient is?
Yes, my Lord, the patient is permanently provisionally fit from ENT point
Why
of
provisionally fit?
Well, at that I do.
That is not the correct certificate. That will not come in your aid. Why patient is provisionally fit
to be operated
from ENT point of view?
Operation
that is no certificate at all.
Well, this
Provisional fit certificate will not come in your aid.
Well, this has been declared by the
Then how, on the basis of which this you can make out a case?
Well,
if you are provisionally fit, then you have no case. Guidelines is will come later. Why provisionally fit?
Well, that I do not know why they have the ENP specialist written so the provisionally.
You file a report. Issue.
Well, this is a fit case. Well,
No, I am not satisfied with the documented page 24. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner participated in the selection process for being appointed as Constable GD under Central Armed Police Forces within bracket CAPMSC. Stop. In review medical examination conducted on 6 December 2025, petitioner was declared unfit on the ground petitioner was declared unfit due to deviated nasal septum. Stop. Next paragraph. Concerned respondent authority is directed to file a report disclosing as to why petitioner was declared medically unfit based on relevant provisions of revised medical guidelines. Stop. Let such report be filed by 3 weeks from date. Stop. List the matter under the same heading for further consideration on 9th February 2026. Every service বলেছি তো উপরে করে দিই। Next.
Item number 18.
18, my lord, I am for the petitioner. It's my affidavit of service.
যেটা বলছি করে দাও
17, 18. Review, my lord.
দুটোই হয়
দিয়েছে, নাম দিয়েছে।
17 তো
নামটা দিয়েছে এখানে।
My affidavit of service. My lord, page 17 is the for initial rejection on the ground of unable to sit squatting position. This type of ground, nowhere it has been mentioned in the in guideline. And
file report
My lord, unable to sit in
squatting position.
yes,
squatting
there is
position.
no such ground at all in the medical guideline.
So let them file a report
page
on what basis they have declared petitioner unfit. If this is not a ground, then they have to consider justify it based on the guidelines.
Yes,
Yes.
sir.
File your affidavit of service.
Yes, I have.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner participated in the selection process for being appointed as Constable GD in Central Armed Police Forces within bracket CAPFS. Next paragraph. In review medical examination, which was conducted on 29 November 2025, petitioner was declared medically unfit on the ground that petitioner was unable to sit in squatting position. Stop. Next paragraph. Concerned respondent authority is directed to file a report in the form of affidavit disclosing as to why
After 4 weeks, my lord.
disclosing as to why petitioner was declared medically unfit based on revised medical guidelines. Stop. Let such report be filed by 3 weeks from date. Stop. List the matter under the same heading for further consideration. If you go on bargaining, then I will make it 1 week. I am not directing to file a report in the form of affidavit.
No, my lord.
Then file it by 7 days.
No, my lord.
List the matter under the same heading for further consideration on 9th February 2025.
Item number 19.
19, may I please, your lordship, I am for the petition. This is my affidavit of service. My lord, here diverse of opinion, my lord. Page 21 is the first rejection order. My lord, will find.
Review, my lord, is declared fit, my lord.
Yes, in review you are declared fit. Page 24.
No, my lord. Page 22 is the review this year. That is the earlier occasion.
No, page 24.
Review
Come
the
to page
physical
24. Review medical examination conducted on 31st July.
Yes, that is the, my lord.
Oh, this is old selection process.
Yes, selection process on same ground declared fit. That's why I annex that document. My lord, page 21, initial one, by the detailed medical examination board. Here, diverse of opinion of both the doctors. My lord, vitiligo on genital. My lord, and
Knock knee. It says knock knee.
page 22. My lord, that is page 21. My lord, this year.
On 3 points, my lord, not only knock knee, my lord.
Page 21, one ground. And page 22. My lord, vitiligo.
Just a minute. Review medical examination, page 22.
Page 22.
24. Review to 20.
File a report. File a report. Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner participated in the selection process for being appointed as Constable GD in Central Armed Police Forces within brackets CAPFS. Stop. In review medical examination which was conducted on 2nd December 2025, petitioner was declared unfit due to vitiligo. Stop. Next paragraph. Concerned respondent authority is directed to file a report in the form of affidavit disclosing as to why petitioner was declared unfit based on
review medical examination. They have not stated that I have been declared unfit on vitiligo.
detailed medical examination dated at all.
Yes,
Just
review is another. Discolored patch over.
Disclosed patch.
They are not saying that this is the vitiligo.
আচ্ছা কি বলছিলাম দেখো তো রাইট রাইট ইট ইজ ডিটেল মেডিকেল এক্সামিনেশন রিপোর্ট রিভিউ হ্যাঁ কি বলছিলাম which was conducted on 6th December 2025. Petitioner was declared unfit due to disclosed patch based on opinion of dermatologist dated 6th December 2025. Stop. Next paragraph. Report in the form of is directed to file a report disclosing as to why petitioner was declared medically unfit based on based on revised medical guidelines. Stop. Let such report be filed by 3 weeks from date. Stop. List the matter under the same heading for further consideration on 9th February 2025. না না সব না কোনোটাই এফিডেভিট ফর্মে দিইনি কোনোটাই এফিডেভিট ফর্মে দিচ্ছি না সিম্পল রিপোর্ট
Item number 20.
20, may I please, Your Lordship? This is my
22 and 23, my lord.
yes
Page 22 and review
page
20.
22 is the detailed medical examination report. Two different opinions. Well, in detailed medical examination say something. In review medical examination board say
hypertrophic scar on left
another,
shoulder.
Another.
File a report.
Another different ground.
Issue. Affidavit of service filed on behalf of the petitioner is hypertrophic scar is a ground under the revised
Kindly
guidelines.
have a look page 25. I have pictured. I have annexed. What sort of
That I will not consider.
well, at the
Picture I will not consider. It's a read code. Based on the guidelines, court has to, and the papers which are available, court
they
has
are
to decide.
founding. They are founding.
It's not a fact-finding court.
They are
Yes.
mentioning
Affidavit affidavit of service filed on behalf of the
purview of
petitioner is taken on
guideline.
record. Next paragraph. Petitioner participated in the selection process for being appointed as Constable GD under Central Armed Police Forces within brackets CAPFS. Stop. In revised in a review medical examination conducted on 25th November 2025, petitioner was declared unfit due to hypertrophic scar on left shoulder. Stop. Next paragraph. Concerned respondent authority. Now, let such report be filed by 3 weeks from. Concerned respondent authority is directed to file a report disclosing as to why petitioner was declared medically unfit based on revised medical guidelines. স্টপ। তারপরে না একটা প্যারাগ্রাফ সেন্টেন্স মনে হয় আগেরটায় মিস করে গেছি। লেট সাচ রিপোর্ট বি ফাইলড বাই 3 weeks